Thank you, Mr. Chair. Before we get to the substantive question of what to do with crypto, we as a country have to answer a more fundamental question. Who among us should get to decide the future of emerging technologies like crypto and blockchain? Should it be Chair Gary Gensler, an unelected bureaucrat who answers only to himself? Or should it be the United States Congress, whose members are elected by and therefore accountable to the people? And so, Mr. Allaire, do you believe, as I do, that an act of Congress would be the most democratic means by which to decide the future of digital assets?
Thank you for the question, Congressman Torres. I do agree, and in fact, the Presidential Working Group specifically asked Congress to act urgently on this matter over a year and a half ago. And so I believe it's critical that Congress does take ball control here.
You know, there are crypto companies like Circle that strive to be compliant with the law, and then there are crypto companies that seem intent on willfully evading the law. And yet Mr. Gensler appears to see no difference at all between the two. He treats them all as one and the same. His enforcement has been indiscriminate in nature, which brings me to the lawsuit against Coinbase. Mr. Garrison, if the SEC sincerely thought that Coinbase was operating an unregistered securities exchange, then why on earth would the SEC approve Coinbase as a public company? Or why would the SEC not at a minimum require Coinbase to disclose its status as an unregistered securities exchange as a material risk to the investing public? Do you see a contradiction between the SEC's 2021 approval of Coinbase as a public company and the 2023 enforcement action against Coinbase?
I do see a contradiction. As part of the filing review process, taking a filing effective under the securities rules requires a public interest finding. Typically, a public interest finding, it's a very loosely defined term, but you might argue that a act by the company that is inconsistent with securities laws, what might be not in the public interest.
And I want to interject, the SEC made the following statement in the Coinbase lawsuit. It said, declaring effective a Form S-1 registration statement does not constitute an SEC staff opinion on or an endorsement of the legality of an issuer's underlying business. So when it comes to S-1 registration, the SEC is asserting that it has no opinion on whether an issuer is complying with the very laws that the SEC is charged with enforcing. That strikes me as strange. It's almost as if, suppose the SEC would approve the mafia as a public company and then say, but we have no opinion on the underlying legality of the business. As a layperson, that just strikes me as absurd. So am I missing something, or?
No, I think that's where the public interest finding comes in, and I think perhaps the other side of that coin is that—
No pun intended, right?
Yes, is that you don't want the SEC to take responsibility for what is in any filing, which is, I think, what's getting at, some of that language is getting at as well.
In an interview with the New York Magazine, Chair Gensler said that everything but Bitcoin is a security. Of the more than 200 listings on the Coinbase exchange, the SEC lawsuit only identifies 13 as unregistered securities. 13 out of more than 200 seems to contradict the Gensler doctrine that everything but Bitcoin is a security. Do you see a contradiction there?
Yes. It would be nice to have clearer insights into what tokens, what digital assets the SEC believes are securities instead of seeing them piecemeal through enforcement actions.
The digital market structure discussion draft provides for a safe harbor, and I see the need for a safe harbor that protects good faith crypto companies from arbitrary and capricious enforcement actions. But what about bad faith crypto companies? How do we prevent bad faith crypto companies from exploiting the safe harbor to prevent legitimate enforcement actions?
So included in the market structure bill are the typical anti-fraud protections that exist in both the securities and commodities laws. So whether a digital asset is sold through the new SEC exemption, the SEC's robust anti-fraud authority would also apply there. And on the CFTC side, if a digital commodity was sold or manipulated in a fraudulent way, the anti-fraud provisions of the CEA would apply as well.
And then a quick question about the applicability of securities law to secondary market transactions. Has there ever been a single statute or a single rule or regulation or a single court case that expressly affirms that the Howey test applies to secondary market transactions?
No.
Are you sure?
To the best of my knowledge, yes.
Are you positive? Okay.
Gentleman's
My time has expired.